Time now is 3:16. We're back on the record.
Mr. Ewers, did anyone on your behalf ever register the Boston judgment in any other jurisdiction?
No, sir.
Never requested anybody do that?
No, sir.
If Mr. Spiro represented that in open court, do you have any idea what he might have been talking about?
I'm not seeing where he made any of those reputations. If he would have, only thing I could, without speaking for Mr. Spiro, because I do not know, but he and I had conversations about doing it in the UK.
I don't want to get into any conversations with your lawyer, but have you done anything in the UK?
Not other than the filing of the statute of demand and securing the bankruptcy.
Okay. Since the entry, or the signing, I should say, of the Boston judgment, I've got a case in Judge Hughes' court, so I've got to get all that stuff straight. Yeah. Have you done anything to look for, try to find any money that might respond to that judgment?
I'm going to instruct the witness not to answer anything that would invade attorney-client or work product privileges as the prior instruction. But you can answer beyond that.
I have not done anything, sir.
Have you instructed anyone to do anything on your behalf to try to locate money?
Same instruction.
Has anybody on your behalf looked for any money?
Same instruction.
Well, I guess that somewhat bothers me. I'm not asking for communications, Mr. Ewers. I'm asking if anyone on your behalf has looked for any money. Can you answer that question?
Same instruction.
I will follow the advice of my legal counsel.
Okay, and trust me, I'm not trying to get you to disregard that advice. I'm just trying to explore the basis of it. So think carefully before you answer me, okay? Are you saying that the only way you could answer that question as to whether or not anyone has looked for money on your behalf is by referring to communications from counsel?
Instruct the witness not to answer for the same basis or same privilege.
Can you answer that question?
I will follow the advice of my counsel.
Okay, so you're refusing to answer that question.
Based upon the advice of counsel.
Okay, Robin. I don't want to beat this, obviously, but unless he says that his lawyer has told him something, I don't think he's established a privilege. I don't think you can refuse to answer a question just by saying that and then not being able to say that, well, I could tell you, except it would divulge a privilege.
Well,
and I'm not trying to push on it at all. I'm just trying to see how we get around it.
go off the record for a moment.
Sure.
Going off the record at 3:19. Time now is 3:20. We're back on the record.
Other than Mr. Painter, who represents you today in anything related to Heron?
Mr. Spiro, due to the Boston litigation.
Anyone else?
No, sir. So let's go back and maybe make sure that we are limiting this to the Heron or to this case, not to the lawsuit that occurred in Laredo, Texas.
I'm talking about efforts to collect any funds that might in any way related to the investment program.
My answer would be no one other than Mr. Painter or Mr. Spiro.
Has any lawyer on your behalf, and he may instruct you on this, I'm not trying to trick you here, has any lawyer on your behalf undertaken any collection efforts with regard to the judgment?
And I instruct the witness not to answer on the basis of attorney-client and work product privilege.
And so you're going to follow that instruction?
I will
obviously.
follow the advice of counsel.
And have you retained any counsel to attempt to, for the purpose of attempting to collect on that judgment?
As previously stated, I only have 2 attorneys that are representing me in any matter concerning the Heron litigation.
Do you have any knowledge of any efforts that, and I'm just asking if you have the knowledge, I'm not asking what the facts are right now, okay? Do you have any knowledge of steps that have been taken to collect the Boston judgment?
I'm going to object to the form of the question, and I'm going to instruct the witness not to answer on the basis, to the extent it invades attorney-client and work product privileges.
I want you to answer this question in a vacuum, in the sense that I want you to disregard everything that you have learned from attorney. You follow me? I'm going to ask the question, and I want your response to disregard anything that attorney may have told you. Do you have
Mr.
knowledge?
Green, could I just back up
Sure.
to save a little time?
Sure.
And that would include anything that he's told to the attorney, any exchanges there? Is that what you're saying? I'm not trying to unnecessarily.
I understand. No, let me ask it my way.
Okay, that's fine.
Do you have any knowledge of any efforts to collect on the Boston judgment outside what you may have heard from your attorney?
No, sir.
Okay.
My desire was, after the settlement agreement in Ozona, that we would have, that the parties would work together instead of fighting among themselves in the attempt to locate funds belonging to Heron.
And you know of no efforts other than what an attorney may have told you. You know of no efforts to collect any of that money.
None whatsoever, sir.
Could you mark this, please? What's the number?
36.
You're right, looks like mine.
Sorry.
Yeah, I am too. Mr. Ewers, I've handed you Exhibit 36. That is a copy of the settlement agreement between you, ICF, and other entities, correct?
Yes, sir.
And that is a settlement agreement that you signed, correct?
Yes, sir.
And your signature was notarized, correct? If you look at page 9.
Page 8 jumps to 14, so give me a moment to try to find page 9.
It goes from 8 to 14.
Yes, sir. It goes from 8 to 10, and there's two pages of 8 here.
Yeah, I've got 2 8s too. Oh, I know what that was.
Here's yours.
Is that your signature?
Yes, sir.
All right. And you signed that and agreed to the contents of this settlement?
Yes, sir.
And you agreed to those contents after talking and getting advice from your counsel?
Yes, sir.
And you relied upon that advice and you were fully satisfied with the advice that counsel gave you?
There was discussions.
I don't want to get into.
I understand. I understand what you're saying.
Let me
But you're
restate-
asking me a question, was I totally satisfied? I believe is the question.
No, my question is, were you satisfied with the advice that you had gotten from counsel?
Yes.
And are you telling me, and I don't want to talk about discussions with counsel, I want to be real clear about that. Are you telling me that you had some question about entering into this agreement?
Yes, sir. I had questions about the shares.
Okay, and tell me what your questions were about the share.
I felt the shares were not what was promised to me. I felt that I was giving up 20% of what was promised to me. And I felt that the reason that I agreed to it was that it would stop the bleeding that I was going through and looking for the money. And the statements that were made in Arizona is that Mr. Smith had found the money, and 30% of $1 billion plus was the reason that I agreed to it.
All right, you said that 20%
I'm sorry, 30%.
that was promised to you by whom?
Liner and Buckley Matthews.
If you'll look at page 5 of that agreement.
Okay.
Paragraph 5.
Yes, sir.
Part of the agreement, part of what you were agreeing to under oath, was that no promise or representation except the consideration cited herein has been expressed or implied by any party or by anyone acting for such party except as expressly stated in this agreement. Correct?
That's what it says. Yes, sir.
What you were swearing to, that this agreement wasn't based upon any representation that anybody had made to you. Correct?
Form.
Not being an attorney and not understanding the legal terms, I accepted it was as it was written
Right.
and based upon counsel.
And your counsel, you had an opportunity to meet with counsel about that paragraph, did you not?
I think that I would be getting into attorney-client privileges if I went any further.
Your counsel wrote that paragraph, didn't he?
Form.
Sir, the question was not who wrote it.
Okay.
Your question was I had an opportunity to meet with him.
Okay.
That gets into attorney-client privileges as far as I understand.
But in this document, you were swearing under oath, put your hand in the air, under pain of perjury, that no promise or representation had been made by any party or implied by any party in order to induce this agreement. That's what you were swearing to, correct?
Objection form.
Yes, sir.
How did you pay Global Securities?
Pardon me?
How did you pay them? By check or cash or? Did I misstate the name? I'm sorry. Was it Global?
Sir, I don't remember exactly how we paid. I think I wired some money. I think I paid some money cash, and I might have given a check. I'm just not sure at this date.
The reason
You
I
have my bank records, so you should be able to tell me.
Well, that's what's leading me there. We see money coming in from Emory in excess of $1 million, but we don't see any checks to Global Securities. How can that be?
I don't know. I can just tell you, I gave them money.
And you don't remember if it was cash or wiring or?
No, sir. I cannot be totally clear on how it was done.
Did you have any other bank accounts at that time?
Objection form, and I instruct the witness not to answer because it exceeds the scope of the rules.
Well, we're trying to find out, you've already testified that you paid Global Security. I'm trying to find out a record of that. And by doing that, I'm trying to find out if you had any other bank accounts. Did you have any other bank accounts at that time?
Same instruction, same objection.
Okay. Subject to the questions that were not answered, which we reserve the right to get a ruling on and reconvene the deposition, I'm done.
Thank you. I have a few questions. Mr. Ewers, could you mark this one, please? Mr. Ewers, I'm handing you what's being marked as Exhibit 37. Could
Yes,
you
sir.
identify that, please?
This was a motion to intervene in a pending lawsuit in Boston, Massachusetts against, the plaintiff was International Strategies Group. The defendants was Corporation of the Bank House, Societal Bank House, and James F. Pomeroy II.
And we retrieved that off Pacer on one of the breaks, is that correct?
Yes, sir.
And could you go to the last page of that and just state the date that was filed?
Dated November 6, 2003.
Mr. Ewers, upon reviewing that pleading, did that refresh your recollection concerning prior proceedings?
Yes, sir.
And I'm going to hand you what's been marked as Deposition Exhibit 23. You recall going over that earlier with Mr. Green, correct?
Yes, sir.
Could you identify that, please?
This is a email from me to Malcolm, and it says Malcolm 4435, which was Malcolm Harris, and SS was Susan Stone, which was the email address that Mr. Playdock was using.
And if you look down on the right-hand column, you'll see that, or on the right-hand side of this, one of the paragraphs is marked. And Mr. Green questioned you about this earlier, correct?
Yes.
And could you read that that paragraph that's marked into the record, please?
Answers to the above were not needed at the time of filing the two other proceedings due to filing prior to Mr. Herron's bankruptcy.
Upon refreshing your recollection with the review of Exhibit 37, do you wish to make any additional comments about your earlier testimony concerning the marked paragraph on Exhibit 23?
Yes, I agreed to have told Mr. Harris a lie, which in fact I was not telling Mr. Harris a lie. We was referring to our motion to intervene, which was filed in November 6th of 2003. And in the event that we was unsuccessful, which I had been led to believe that we would be filing a separate petition in Boston.
Mr. Ewers, I'm handing you what's been marked as previously as Deposition Exhibit 24. You recall going over that earlier?
Correct.
Could you identify what this document is?
This is a document that I sent to Mr. Pike as to on any other litigations.
Now, there's a paragraph toward the bottom there that starts out "at no time." Do you see that paragraph?
Yes, sir.
Could you read that paragraph into the record, please?
At no time have we failed to be forthright with the trustee.
You could read the rest of this.
We will not be a party to any attempt at this time to furnish information to any court concerning assets which may or may not belong to Herron. Until a court rules, it is premature to offer such information.
Based on your review of Exhibit 37, which refreshed your recollection, do you have any further testimony concerning that paragraph that you just read into the record?
Well, what I was informing Mr. Pike is that any information that we may have received about potential monies that belonging to Mr. Herron, that we were not going to file that into any litigation, that's a bad word, into the litigation in Boston until such time as the Boston court had ruled.
Now, correct me if I'm wrong, but I think earlier in your testimony, you stated that you believed that you might not have been forthright with the trustee. Is that still your opinion?
No, sir.
Could you
No,
explain?
sir.
And could you
I'm
explain?
totally of opinion now after looking at Exhibit 37 that I was and have always been forthright with the trustee.
Now, there have been 37, or I don't know, how many exhibits have we gone through today? 37 exhibits.
Again, Mr. Smith is enjoying a good laugh.
Up to, Mr. Ewers, up to Exhibit 30.
Not working.
Objection, non-responsive.
Mr. Smith, do we need to go off the record for a minute, or?
You can do whatever you want.
Hey, don't talk to my client.
Well,
He's not been deposed here. Don't talk to him.
Mr. Green, I'm going to object once again to Mr. Smith and his unprofessional and unruly conduct at the deposition. And I just want to make it a record, this is the third warning.
I don't care how many times you want, because I don't know what you're talking about. Now, you want to finish this deposition or not?
Well, I'm going to continue to record my objection. I have personally observed Mr. Smith's conduct. I've personally observed inappropriate gestures, mouthing of obscenities, and so forth during the deposition.
He turned around and started watching the monitor just because your client was sensitive. Now, what do you want him to do?
Well, he's apparently he's back to his old tricks, and so.
Let's get through the deposition. You made your objection. Let's just get through.
I object to the sidebar, and I'll continue my objection, and we'll proceed when I feel like it.
I object to your sidebar.
Now,
See, we were getting along so much.
well, there's precedent here, Bob. So I think I've made my objection adequately there for the record. Now, Mr. Ewers, my last question here, I believe. Mr. Green has introduced 36 exhibits today. Is that correct?
Yes, sir.
And has it been your intention to authenticate any of these exhibits 1 through 36 today?
No, sir.
Pass the witness, and we'll reserve remaining questions for time of trial.
But you gave me true testimony with regard to those exhibits, did you not?
Based upon the exhibits that I was looking at, yes,
Yeah.
sir.
When I would ask you a question about the exhibit, you'd tell me the truth.
Yes, sir.
All right, thank you.
Yes, sir.
Time's 3:40. We're off the record.